Any mention?
Yes. Yes.
When my I have taken the consent of the other side. Similar matter is similar issue is pending before the Honorable Division Bench, before your Lordship also. So let this matter may come up after 2 weeks, my lord, or
The
3 weeks.
adjournment I am not objecting, but the submission that is similar matter is pending, that I don't think any similar matter is pending.
That is not correct.
That's not correct.
Yes, Mr. Sandhu. That is what the Majika's contention, that there is no similar matter pending.
In fact, this
Anyway,
matter was heard by
All right, my lord. No problem. All right, my lord. No problem.
just said the request of the petitioner. This is matter after 2 weeks. 2 weeks.
Can be 3 weeks, my lord.
3 weeks. Make it 3 weeks. Yes.
Obliged, my lordship. Deeply obliged.
May I please, Your Lordship? Item number 8, my lord. I was directed to produce the record. I have received the record yesterday, my lord, but I want to classify it, so it will be for the
Only the relevant part can be
only the
received.
relevant part, my lord. Yes. So I have received the file. The entire file is a bulky file, my lord. I have to go through. So if some time may be given to me, my lord, I'll need 3 to 4 days time only, my lord.
Yes.
No objection, my lord.
Also 8. And the request made by Mr. S. J. Leonard Council appear for the respondent number.
Respondent number 1 to 3, my lord.
This is matter after 2 weeks.
1 week will do, my lord.
1 week.
Lordship. Much blessed, Lordship.
I will please, Your Lordship. Your Lordship, I beg to make a mention for item number 12, Your Lordship. Your Lordship, I pray for 3 weeks time, Your Lordship.
What is the matter about?
Your Lordship, it's related to for gender. This 354, Your Lordship.
354.
Yes, Your Lordship.
Outraging of modesty.
Outraging on modesty 354, Your Lordship.
Petitioner is seeking quashing of that.
Yes, Your Lordship.
Yes.
No objection.
This also. At the request made on behalf of the petitioner. This is matter after 2 weeks.
3 weeks, Your Lordship.
3 weeks. Yes.
Obliged, Your Lordship.
Lordship, I beg to mention item number 13, 13, Lordship.
Yes.
2 weeks, Lordship. I pray for 2 weeks time, Lordship.
2 weeks.
2 weeks.
No objection.
Apply.
The parent. Grant of 2 weeks time. The parent is. The appellant is granted. Just pray for the. Also for the appellant. Yes.
May it please, Lordship. Lordship, I beg to mention item number 17, Lordship.
Yes.
I have no objection.
What is your prayer?
Lordship, this may come up after maybe after 2 weeks, because Lordship, like a similar case as Your Honor has
Pending before a
yes,
decision.
Lordship.
Okay. So we'll have it then after 3 weeks then.
Yes.
The request made on behalf of the petition. This is made after 3 weeks. Yes.
Obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item number 9. Lordship, I pray that this matter may be taken up after 3 weeks, Your Lordship.
After 3 weeks.
Yes.
Yes. Who is the other side? Item 9. No one is here.
Still, I am there, Mother.
Yes.
Yes.
Any objection to the prayer?
No objection.
Yes. Yes. Also. The request of the petitioner. 2 or 3 weeks.
3 weeks, Your Lordship.
3 weeks. Make it
Highly obliged. May it please, Your Lordship. Lordship, I beg to make a mention of item number 11
Yes.
on behalf of the petitioner, my lord. Can you have the matter after 2 weeks, my lord?
No objection. This is also 2 weeks of the request of the petition. Item 11.
Deeply obliged.
Please, Your Lordship. Lordship, I beg to mention item number 16. Yeah, for the respondent number 2, Your Lordship, I'm praying for some accommodation.
Yes.
2 weeks, Your Lordship.
This is for petitioner.
I've already informed the petitioner, Your Lordship, Mr. Jishila.
This is also 2 weeks of the request made on behalf of the respondent number. So and so. So right. No objection for this.
No objection.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 15.
Yes.
I pray this matter may come after 3 weeks.
You're making a mention on behalf of the petitioner.
Yes, Your Lordship.
No objections, madam.
3 weeks.
Yes, Your Lordship.
This is what I can question.
Question.
Implication. This also 3 weeks of the request. Yes.
Team
Your
leader.
Lordship.
Your Lordship, with the consent of the petitioner, I beg to mention item number 4, Your Lordship. I'm praying for 3 weeks' time, Your Lordship.
Why such a long time?
I will inform them.
Item 4.
Yes, Your Lordship.
You appear for the Union of India.
For respondent
From the AG
of
Accountant General.
Yes.
No objection, ma'am.
Yes. This is also 3 weeks of the request of so and so. Yes. As a request made on behalf of us. Your respondent number?
789, Your Lordship.
Yes.
May I please, Lordship? I beg to mention item number 14, Lordship.
Yes.
For 2 weeks, Lordship.
Yes, you are yet to have instruction. That is the same matter.
Yes, Lord, same. Instruction is waited, Lordship. Yes.
2 weeks. 2 weeks.
Supplementary cause list, item number 1.
Yes. What is the matter about, Mr. Jha?
My lord, this restoration application, my lord, it was dismissed for default, my lord.
It was dismissed for default
My lord,
of non-appearance.
my lord,
Where is the order?
my lord, in extra 1, page 9, my lord.
Yes.
Yes, Lordship, we have an instruction, Your Lordship, no objection.
Yes. Heard Mr. Arjun on a council petition, and also Miss London Council, Miss K. Gurung, London Council, appearing for the respondent. Your paragraph. This is an application for recalling of order dated 8th August 2024. Passed in WPC number 221 of 2018, by which the writ petition was dismissed for non-appearance of the petitioner. The paragraph stuff, it is contended by the petitioner that contended by the petitioner that the reasons for the previous non-appearance was not intention and was for the reasons of urgent medical need of the counsel appearing for the petitioner. This paragraph says the respondent has no objection to the prayer made in the application. Then paragraph is in view of the above the causes shown, the cause shown for the non-appearance of the petitioner for previous non-appearance is found to be good insufficient. Stop. Accordingly, the order dated 8/8/2024 stands recalled. Stop. The writ petition number 221 of 2018 stands restored back to the file. Then there is this application is allowed. Yes. Oh, in the writ petition, just in the writ petition, it's in view of the order passed today in this case number 150 of 2024, comma, the writ petition stand restored to the file, restored back to the file. Stop. When shall we restrict?
Next week, man.
As requested by the parties, this matter after
Much obliged, Lordship.
this will be in the writ petition number 221. 3 also, my
Three,
lord.
same.
Another case is there.
Yes, Lordship.
Same reason. Same order.
Same.
In both things, same order. In the next case also, and this. Yes.
Much, much.
Olive, Lord.
Daily cost list, item number 1. Item number 3.
Nobody is appearing.
On the last occasion, the petition appeared, Your Lordship. They have prayed that they'll be filed. They'll be filing the Vigatnama, Your
They have
Lordship.
filed it. That is on the record. That is what the office notes is. This has been filed by the non-actors. Non-actors. This is the review application. Okay?
Yes, Your Lordship.
Because the main petition stand disposal, is it?
Yes, Your Lordship.
It's non-actors for the petitioner. Miss Gurung is present for the respondent. Is this matter after?
Much, much, much.
Hearing item number 5.
Yes.
Lordship, I'm praying for some time in this matter. I'm not well versed for hearing, Your Lordship, for the day. I'm praying for some time, Your Lordship. I'm not well versed for hearing for the day.
What is the matter about?
Lordship, this matter is a Gaubra matter where we are challenging the order passed by the district council, where I was removed from the post of Gaubra and the respondent.
You are claiming for the post.
Your Lordship.
And who is been appointed here?
The respondent number 7.
It's a Nokma.
No, Gaubra, headman.
Headman, the petitioner appears from the name appears to be non-tribal.
In the plain belt, headmans are mostly non-tribal, Lordship. Nokmas are all Garo.
Is there any law regulating that?
No, there's no impediment for tribals or non-tribals. Anyone who is
See what provision guides the appointment of appointment of headman?
rules are there, Lordship, under the
rules are there.
Assam and
So that rule is not confined only to the election of tribal people.
No.
Unlike what we see that say like the headman
In the
here,
Khasi Hills and all, that rule, yes.
We are bound in
customary practice.
yes,
Galo is
customary.
And then district council has set of laws prescribe the manner and mode of appointment.
Your Lordship, the respondent
Now,
number 7 also
so
is
far
a
as the
non-tribal.
this is a Garo Hills,
Garo Hills, yeah.
and this will be guided. This will be guided by what provision of law?
By the
This appointment
Lordship, the appointments are there under the Assam Land and Revenue Regulation.
of headmen.
Lordship, yes.
Assam Land and Revenue
I'm sorry,
Regulation have this thing provision for appointment of headmen.
I'm sorry, Land and Revenue Regulation of District Council, which is basically the adoption of
That is what. That is what. So it contains a provision for.
Yes, yes.
District Regulation 1 of 1994.
Lordship.
Yes, no. Then District Regulation 1984 by which it was amended. The Assam Land and adapted. Assam Land and Revenue Regulations. Now the Assam Land and Revenue Regulation has the provision for appointment of headmen also. Is it correct?
Lordship, yes.
Is it correct?
This is the regulation.
This is the regulation.
Annex in my affidavit.
In fact, in the Garo Hills, most of the it's divided into two parts, Lordship. One are called hilled mozas, where there are aking lands basically.
Yes.
There is no headman and all.
Nokmas.
And the plain belts, plain mozas, there they have headman directly under.
And what is the manner of mode of selection of headmen?
Lordship, it is usually by way of election, and sometimes in view of
who conducts selection? District Council.
District Council. And sometimes selection if there is no opposition and no. It depends on the wishes of the villagers, Lordship, and a preference is given to the family members of the last headman.
Okay, it can be done by consensus also. Consensus.
Yes.
Also. It is not necessary that
there is no mandate that it has to be an election. Yes.
So what here you are challenging the election of?
Sir,
here they are saying that Lordship, the CEM had no power to cancel because the regulation at that point of time said deputy commissioner. Now, thereafter an amendment has been carried out.
Yes, definitely that should be something.
After
yes.
So earlier all notification was filed, it was disposed on the basis
that deputy commissioner. Yes.
In fact, there was a amendment to that effect where the tribunal is not required.
It will be the CEM.
That is what, and then I think that so far as that thing, that deputy commissioner,
yes. Deputy commissioner would be an executive member, and
those
board
were substituted by this.
Yes. Board would
an
name
amendment.
The
That is why we went for.
So that means there remains no other thing than controversy. Then is there anything?
So now they have to say on merit because initially they got the order set aside on that.
That was the
authority.
main condition.
Yes, yes.
So now you have some
you have
more.
to go on merit.
That is pleaded in the writ petition.
Yes, Lordship.
All those grounds.
That because
file your affidavit.
Our affidavit is only limited to that issue of whether the CEM can take
is
up
it
the
your
matter.
case that the new points which
because
the
order of disposal was in their favor.
Yes.
They filed a review and the petition was restored to its original position. And their petition was set aside.
Order of disposal by this court.
Yes. It was allowed.
Review was filed
in view of the amendment.
And what is the ground of review? What is the ground of review? Review was allowed on what? But the review was allowed, but then this order stands. You have been allowed only.
Yes, so I believe the writ petition still remains on the.
What is the ground of review?
Amendment.
No, on the amendment, the amendment was not brought before the.
Okay, so earlier order was passed basing on the conception that.
Your Lordship, in the earlier order, the respondent 7 never appeared. There was an ex parte order which was passed against the respondent 7.
And then
hearing.
That amendment was also not placed before.
It was not placed.
But then you did not contest the earlier.
Yes.
In spite of the fact that you
That's
are.
why we filed a review on the basis of notice and the new law.
Now writ petition, in the writ petition, the plea is confined to that issue only, or there are some other pleas also?
In the writ petition, they have challenged the CM's order, which
On the ground that it's not maintainable on law, not facts.
No, which your CM's order is coming? You said that this order was passed by this High Court.
No.
Which was reviewed.
The CM set aside her appointment. They came up with this writ petition saying that CM does not have the power because there is no tribunal under the Act. High Court on that limited line, without taking into consideration the amendment,
yes, we can understand.
set aside the order. They filed a review and the writ petition is
all right. That is all right. Now the very ground on which the CM's order was issued
perhaps does not survive anymore.
If that was confined to the issue of the exercise of power by the deputy commissioner, that means in view of the amendment, that issue does not survive for.
As far as the authority concerned, there is no doubt.
There is a thing. Now, apart from that point, Is there any other point raised in the writ petition? That is what the court is asking.
Your Lordship, the other point that we are raising here is because the respondent number 7, there were various complaints by the villagers. So on that ground, Your Lordship.
Complaint by you also is there.
Lordship.
Have you filed a complaint?
Your Lordship, the villagers have filed a complaint, and moreover, respondent number 7 is not a resident of the village.
So is it a requirement that he has to be a resident of the village?
Your Lordship, if the headman is not present in the village, how will the village function?
That is, do not go by assumption. What tell us about the law? Is there is a requirement? If there is no bar, then I can go even in contest there. If law does not impose any bar, you will find in more election process, you will find the candidate from Gujarat contesting in UP. Can a candidature be rejected on the ground saying that he is not from this area? So there has to be a specific legal bar, isn't it? That has to be studied procedure.
But Your Lordship, on the basis of the complaint of the villagers, there was an inquiry conducted as well. And on the basis of this inquiry, they found that there were certain malpractices by the respondent 7.
Malpractices at the during the election.
No, Your Lordship, as a headman, there were certain schemes which were not given to
Now,
the...
your challenge in this writ petition is what? To his election or to his continuation in the post?
We'll go to the prayer and the writ petition.
At page 11.
Page 11.
This is what? This is not to give up to the impugned judgment or order dated 14-2. It is judgment
by the CEM. Against that order, we have come here.
So it is. This is confined to the thing, that order.
Order.
That whether revision at all could have been entertained by the CEM. Their prayer was that whether this Lordship will kindly have the order at page 44, the impugned order.
Page 44.
Lordship, Annexure 6.
It's a long order. Seems like a long order, is it? Yes.
If Lordship will kindly see, I have perused this revision petition of the petitioner dated so and so, along with annexures so and so. I have
This is a revision petition or review petition.
Kindly see the next paragraph, Lordship. The petitioner initially prayed for revision of the order in which revenue member confirming an erroneous and illegal order passed by the revenue officer dated so and so. Later, the petitioner submitted before me to convert his revision petition as review petition. Opposite party has no objection in hearing the revision petition as a review petition, and the matter was heard.
You see, then this review was of which order?
Review of the
I'll just place this. It's simplified in matter.
See, since here prayer has been made by the petitioner for grant of time, so we'll definitely give her time.
Yes,
because-
no problem. You will hear the
But then
matter.
we'll just, if we get the outlines of things, then it becomes easier. Yes, what part, which part you want to?
Yeah, I'll just square this.
Yes.
On 2/4/2012, there was
No, yes,
I was
Kavura.
appointed as governor. There was a complaint thereafter, Your Lordship. That
Complaint by whom?
is against me.
By whom?
At the other side.
What is the ground for complaint?
There was it's a personal complaint, so it was dismissed.
Not in relation to your
Not in-
election.
Not by the public.
Not in relation to your election to the office.
So something to do with my conduct.
The conduct,
So that the
see,
authority dismissed the complaint.
conduct comes subsequently when disqualification is sought. Your continuations is sought to be interfered. But then very election is something different. Challenge to the very election is something different.
Different.
Misconduct can be,
Not about election.
yes. So it is not about election.
Not about it.
But then it is about
Some
yes.
complaints against him. So that complaint was dismissed since it was in his personal capacity and for his own personal interest
dismissed by?
by the authorities, by the district council.
Yes.
Thereafter, Your Lordship, a writ petition was filed challenging the order dated 21/5/2013.
WPC 180.
Then he was remanded back.
Lordship.
For
Give
fresh
opportunity, yes.
You were a party there.
Yes.
Then?
Now what has happened?
So pursuant to that order, the order was passed by the EM. pursuant to
Just
Lordship, I'm
say
sorry.
one thing. Just
Then Your Lordship, on 18/5/2015,
yes.
I was removed.
Removed. Why?
After I removed,
Election of Gamuda is for life, or it has a particular tenure. The continuation.
It's for life.
for life.
For life.
Now what happened in Lordship, on 18/5/2015, I was removed. After my removal, I had challenged the removal, the Lordship.
Just,
But
my lord, just one point.
One second. Just
Yeah,
we
my
are
lord,
trying to
my
get. See,
My
Mr. Day, we'll not.
No,
going
that
to
part
decide.
what my colleague has submitted, my junior colleague, that is not correct. That's lifetime. It is still you enjoy the confidence of the people. That is only I want to point out.
Otherwise, it is lifetime. Until and
Yes,
unless
otherwise it is a lifetime.
Yes. For life.
Yes.
there is nothing wrong about that.
No, my lord. If it is recorded, then again,
It is
district
conditional.
council will have no power then to remove them, my lord, even if there is a complaint.
Can you say that there is no absolute continuance? There is a regulated continuance.
Yes, sir.
So what happened in Lordship when we filed before the EM? Now what my client did, he filed an appeal in Lordship, filed under section 147 of the regulation 156. In fact, it should be the first appeal under section 162B, appeal to Deputy Commissioner.
Yes.
Now, on 18/1/2016, the EM order was upheld by the appeal. Then what happened again? My client made a mistake. He filed a revision under section 170 of the regulation, whereas in fact it should be a second appeal, section 162C.
But then
An appeal.
it lies before both the things lie before the same authority.
Yes. Thereafter, Your Lordship, after I was reinstated,
You
they
are,
have come before
you are
this court.
reinstated or the order was set aside.
The order was set
Reinstated
aside.
and order set aside. Thereafter, Your Lordship, they, against this 14/2017, they have come before.
Now, what are the grounds taken in the appeal? Main ground, the question of law.
My submission before this court now is wrong quoting of a
What is the ground taken? You do not admit or not admit. Just what is the plain reason gives? Just give us the thing. What is the main ground raised is the thing. Apart from that, the question the deputy commissioner had decided the matter is authority. Now that is apart from that. Is there any other ground or on question of law raised in the writ petition? No. According to you, nothing else. Yes, Mr. Day, what is the main challenge? What is the main ground of challenge in the writ petition?
It was only
of course,
that,
you are not supposed to tell the petitioner's thing.
my
but
lord.
then-
But that what my learned friend has submitted.
That was the only thing.
That is the only ground. But what is my instruction at present, but subject to what they agree, my lord, that if it is required, my lord, because it's, again, my lord, if you come back, what I have submitted on the first point, my lord, is that how much you enjoy the support of the villagers. So now, my lord, lots of water has gone through the bridge, my lord. Now, we are ready to hold an election of both the people. Whoever will enjoy the majority, he will be the headman, my lord. Because all this hodgepodge and technical things,
Petitioner will be happy to accept.
that subject to both, my lord. I cannot,
And now question is that the
my friend,
shareholder.
whether he will agree or not. Because what?
Yes, do you still enjoy the confidence?
I still enjoy and I
So you are ready for a fight?
instructions again on
You
that
let him
basis.
take the
Are
instruction.
you ready? Are you ready for a?
My friend.
Are you ready for a battle?
I'll have to take instructions.
Anyway, if you agree on that, but then otherwise the thing in front of the concerned is low, isn't it? Now, if you go by those things, so now what you would say, the entertainment of your revision application and all, was it the outcome of improper assumption of jurisdiction? And can an order passed by an authority by resorting to improper assumption of power be upheld in law?
Technically, the district council will be in a very bad shape, my lord, if my lord take this ground. More than him, my lord, I have to justify my action. And we will be in a very bad shape. That is why, my lord, the first proposition came, my lord, that we are ready to conduct an election if both the parties agree, my lord. Because those technical things are hitting me very badly. My lord.
because they are the
Otherwise,
ones
you see, like you are right when you say that these are posts. You see, like where a person has been elected by following democratic process, and you hold that position so long, you enjoy the confidence of it.
Yes, yes.
So, keeping aside the technicalities involved, if parties are ready, then it's a good thing.
My friend can take the
I'll
instruction.
take instruction.
Because again, if we go in the letter and spirit, my lord, it will be very difficult to sustain this order. But again, my lord, if this order is set aside, automatically the petitioner will become the headman, because only the order will be set aside. Because by this order, my lord,
How petitioner can become headman?
because he was the headman, my lord, earlier headman. Yes, and all this has been challenged by my learned friend client before the district council. Now, if the district council order is set aside by this honorable court, indirectly he become the headman, my lord. Now, that will be again a risk for him if you want to argue this matter. That is why, my lord, to put in balance, my lord, whoever enjoys the majority of the village.
You convince him.
No, my
outside
lord,
when
he's
you
for
visit.
him to do
Give him
this.
the thing. And madam, you also take
I'll
instructions.
take
Just see.
instructions.
If we can have an amicable settlement, that is always welcome. Just say that whether your client is ready for election or not. And if he says not, then we'll understand that it doesn't have the popularity. When shall we have it? At the request meet, joint request meet, at the joint request meet with the parties, list of applicants. You're not writing anything about instruction, you just have it of your own.
No.
You're not recording that there is. Or otherwise, you see, Mr. Nangvi, be ready for some technical questions. You have to answer, even if the petitioner doesn't raise. You will enlighten the court.
That is why I don't want to open the file, my lord. If it can be settled without opening the file, that will be the best thing, my lord.
This, see, Mr. Day, in any litigation, any sort of settlement is always welcome.
Yes, ma'am.
It's always welcome.
Subject to my learned friend whether he will agree to this proposition, my lord.
The problem is that it is not only the creation of the relief of the parties concerned, even the lawyers also want it.
Yes, yes.
Now it's subject to my client.
All right. We'll have it. Yes.
Lordship,
How many meters are there? 2 meters.
Lordship 6 is also similar, almost similar.
In 6, my lord, what happened, my lord? It was.
See, Mr. Dave.
My lord.
Cannot give you time. You have to.
Yeah, my
write
lord,
the
sure,
petition.
definitely.
No, but then are you ready to take up the matter number 6?
6, my lord, the order can be set aside and remanded back, my lord.
Then we'll come back. Just see. If
My lord,
at all
because
we can see.
the motion matter is also pending. Mr. Khan will be available at that point.
Yes, we'll just see.
My lord, we'll wait, my lord. We'll wait.
Item number 6.
Your Lordship,
Yes.
Your Lordship, in this matter also I'm praying for some time. Your Lordship.
This is what? This is the same issue.
No, Your Lordship,
madam, it
this
is the patta.
cancellation of patta.
Cancellation of patta by the district council.
District Council.
This also will be a matter under Land and Revenue Regulation.
Yes, my lord.
Here also we are challenging the order passed by the CM.
Any private respondent here? No.
Yes. my lord.
Why? Why private respondent is there? So then, patta of the petitioner has been cancelled, isn't it?
No, my lord. They are coming and challenging the non-cancellation of the patta of the private person.
Non-cancellation.
Yes.
What right they have?
My lord, they are the NOCMA. They are claiming they are the NOCMA, and the documents was obtained, my lord, fraudulently. That is, let her place the case. That is the allegation. Now, only thing is this. Now, whether the EM and CM has the power to cancel the patta. That is the issue, my lord, before this honorable court. If my lord
Or
see
otherwise,
Jana Mara,
or otherwise, if there is a fraud,
sorry, my lord.
if there is a practice of fraud in obtaining patta,
Yes.
what would be the thing? Do you say that
It is a
will
civil
not have
court. It is a civil court, my lord. But fraud has to be established on that part, my
You
lord.
want to say it's civil court?
Yes.
Cannot be, of course.
No, but as if my lord see Assam Land and Revenue Regulation. Now, Janar Marak is one judgment which was passed by Justice Shaha.
UB Shah.
UB Shah, my lord. He says, my lord, that once the patta is issued, it cannot be cancelled. There is a single bench judgment of the then Guwahati High Court Shillong bench. I was a party to that, my lord. Now, that, my lord, order, according to my understanding, even though, my lord, it should have been the argument of the petitioner, my lord, because the law is involved. The law is otherwise. The rule, sorry, my lord, the rules is otherwise.
And we'll just see. When?
After 2 weeks, Your Lordship.
Yes. At the request made on behalf of the petitioner, this after 2 weeks. Yes.
Item number 10.
Yes.
In this matter, I'm praying for some accommodation, Your Lordship, on behalf of Mr. Estapa, Your Lordship.
Some accommodation. You always take all the accommodation.
Lordship, here the matter involves like they need to go to tribunal, Lordship, and they need instructions whether they will be going for tribunal or whether they want to proceed with this matter. So, Lordship,
Yes,
it's
Your Lordship,
now.
yes.
So you do not have any instruction.
No, Lordship.
So when
Lordship, quite long time, Lordship, it is pending for instruction, Lordship. Lordship, recent judgments from Supreme Court also what has fallen from Lordship's on last occasion
yes,
that
the
Supreme
writ
Court has
petition will not be
opined.
maintainable if the provisions of appeals are there, isn't it? There is statutory.
Lordship,
If
statutory law.
That is what the latest judgment. Any
Lordship.
and then advise your client accordingly.
Lordship.
When?
2 weeks, Lordship.
Yes. This also 2 years. 2 weeks at the request. At the request meeting. Yes.
Obliged,
Second
Lordship.
call. Supplementary cause list. Item number 1.
I'll take 2 minute time, my lord, of my lord, to place my case.
No, it is not
Now-
that, Mr. It's not a question of 2 minutes or 2
All
hours.
just two submission, my lord. Now, my lord, the request which was made by us, not as per the law,